Hello, everyone. Welcome to Bardia Perry's session on the workers' compensation legislative reforms. I hope everyone is well, and I can see in the chat that there's quite a few people that I know and we've interacted with, so welcome to those people I have previously dealt with or we've previously worked with, but also welcome to all of the new people who may not have interacted with Bardia Perry. First of all, let me start by beginning by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to elders past, present and emerging, and I recognise their continuing connection to our land, waters and culture. And I also particularly wish to extend my respect to Aboriginal and Torres Strait Islander peoples here today. So today's session, we're recording, and the recording and the slides will be disseminated to everyone after the session today. If you have any burning questions that you would like to pose to Maddie and I, feel free to put them in the chat. And then at the end, I think our people will be asking you to give us a little bit more time to fill in a quick survey for a review of this session and for suggestions on how we can deliver further and better sessions in the future. Today's talk will be delivered by my talented colleague, Maddie Chaplin, who is all over the statutory reforms, and then I'll have some modest input into the talk. The order of business today is to briefly talk about the status of the reforms. Maddie's then going to walk your way through the new definitions for psychological injury, tests for causation, and all things eligibility. She'll also speak to you about a new and enhanced Section 11A defence. Then the focus will shift on me and I'll take you through what the claims and disputation process looks like in relation to psychological injury, with some examples of practical implications and observations at the end. So hopefully that will give you some insight into these reforms. But I've got to say, they're not law yet, and they don't look like becoming law anytime soon in the next few weeks or perhaps months. These reforms commenced with an amendment bill which was passed by the lower house of Parliament, the Legislative Assembly, on the 3rd of June. And then the bill moved by moved to the upper house, the Legislative Council, but it was not passed in the upper house. It was referred to a committee of inquiry for public hearings, which occurred, and that's where it stopped. I don't believe there's been any final report back on those public hearings. Oddly, the government then introduced a new version of the bill, which is called the Workers' Compensation Legislation Amendment Bill, Amendment brackets Reform and Modernisation Bill, on the 6th of August 2025. And that sits in the lower house of Parliament, and there's been a second reading speech, but it hasn't moved from there. It hasn't been debated. It hasn't gone to the upper house. I had a quick look at the parliamentary website this morning to see what was happening, and I reviewed the second reading speech of the Minister, Sophie Kotsis, and I'll just read out a couple of paragraphs to you to signify the government's intent. My message to the opposition is very clear. What they have been doing is wrong, i.e., not passing the legislation, and they have to listen to their local communities. Card-carrying Liberals are speaking to me and are absolutely disgusted in the opposition members who are trying to stifle important reform. We all agree that the current system is broken, and many are concerned that the rising workers' compensation costs threaten their ability to continue to provide services to the community. At the round table with the not-for-profits, the Premier, the Treasurer and Treasury officials, together with iCare officials and I, heard one disability service provider describe an 800% hike in premiums over the past 5 years. Others have reported diverting funds from disability support programs to pay for premiums. Each day that reform is delayed, the workers' compensation system deteriorates further. The nominal insurer is going backwards by $6 billion per day. It is soon expected to hold only 80% in assets for each dollar it will have to pay in claims. Without reform, New South Wales businesses will need to see premium increases of around 36% over the next 3 years, on top of the 26% already seen over the past 3 years. Workers need to know that their compensation entitlements will be fully funded into the future. Promises of support for injured workers are meaningless if the scheme remains underfunded and unsustainable. So, putting aside the politics in all of this, one thing is for certain, and that is that the workers' compensation system, particularly when it comes to dealing with psychological injury, is not fit for purpose anymore. And everyone agrees that reforms are warranted. But we just can't get agreement on what these reforms should look like in terms of eligibility or continuing eligibility at this point. But I believe that they will happen, and I believe that they will largely happen in the way that Maddie and I will talk about today. So that's my introduction. My take home on the introduction is it's not law yet. So view everything that we say today against that background. And when the bill becomes law, there could be some significant differences to what we are saying today. So over to Maddie, who will talk to you about all things eligibility and definitions.
Alrighty, thanks, Nick, and good afternoon, everyone. So for today, for this discussion, I'm going to focus mostly on primary psychological injuries. So there's a new interpretation of that and new definitions that come along with it as well. So Section 11A3, as we knew it, previously defined a psychological injury as a psychological or psychiatric disorder and extended to include the physiological effect of such a disorder on the nervous system. Now that has been repealed, well, anticipated to be, and replaced with the new Section 8D. Now, this section defines psychological injury as an injury that is a mental or psychiatric disorder that causes behavioural, cognitive or psychological dysfunction. Then Section 8C, that defines a primary psychological injury as bluntly not a secondary psychological injury. And it's important to note that these new definitions, they will only apply to primary psychological injuries first notified to the employer on or after the commencement of the amendments. Otherwise, the previous and existing provisions and definitions will apply. So to establish an entitlement to compensation for psychological injury under the new proposed reforms, compensation will only be payable under Section 8.0 if three things happen. First, a relevant event or series of relevant events caused the primary psychological injury. Second, there's a real and direct connection between the relevant event or events and the worker's employment. And C, the last one, employment was and is the main contributing factor to the primary psychological injury. So Section 4, which is in existence, still applies, and that adds those additional statutory tests, as we know, being those for a frank injury or disease injury. But Section 9A doesn't apply to a primary psychological injury. So looking closer into those three requirements, main contributing factor, we have that in the current legislation, so that's unchanged from how it is. There's the additional test of real and direct connection. That's likely to be comfortably established in the large majority of claims, but it's worth noting it's more of a stringent test than the real and substantial connection test that we currently have for journey claims. So this is going to be an emerging area of development in terms of statutory interpretation and what that will mean in a practical sense. But I guess the main point to look at here is, and purpose of our discussion is, what is a relevant event? This is going to be a crucial and key determinant for eligibility. So under 8G, which provides the definition of the relevant events, there are 8 events that are provided. There's one more, which is another event prescribed by the regulations. So that may also be an area that we'll see some changes in. But for what we have now, there are 8. Those are being subjected to an act of violence or a threat of violence, being subjected to indictable criminal conduct, or witnessing a traumatic incident happen, or a dead or seriously injured person at the scene of a traumatic incident, or experiencing vicarious trauma. There's those 4, and I'm separating them. We'll talk about that in a moment. And then the others include being subjected to sexual harassment, racial harassment, bullying, and excessive work demands. Now, for our discussion today, I think it's helpful to think of these relevant events in 2 general categories. So the first 4 being those consisting of violence, trauma, or criminal conduct, likely to be outside the control of the employer. And then the last 4 are more conduct perpetrated against a worker by their employer, co-workers, and others, and the employer is more likely to be held responsible for that conduct. So going back to those first 4 I'd mentioned, being the act of violence or threat of violence, indictable criminal conduct, or witnessing a traumatic incident, vicarious trauma, those are defined in new sections 3, 8J, and 8K. So an act of violence, they pull from the Victim Rights and Support Act, which says, a series of related acts, whether committed by one or more persons, that's occurred in the course of the commission of an offence, involves violent conduct and results in injury or death to one or more of those persons. Indictable criminal conduct means the commission of an indictable offence, being a crime that's a serious criminal matter and can be tried before a judge and jury, and also includes conduct of a person that would constitute an indictable offence if it was not, even if not for the fact that that person may not be held criminally responsible because of a number of factors such as their age, mental illness, that sort of thing. Then looking at the meaning of traumatic incident, that could be any of the following that could result in the death or serious injury to a person. So an act of violence, indictable criminal conduct, a natural disaster, fire or explosion, a motor accident or other accident, suicide or attempted suicide. And then the definition also prescribes for the regulations to expand that if need be. Then the last one, so vicarious trauma, that means the psychological impact of repeated exposure in the course of a worker's duties to the traumatic experience of others that result from traumatic incidents. What do we take from this? I think at this stage, again, they may change, but certain occupations are likely to have more exposure to these sorts of events than others. So some that come to mind may be certain council occupations, so your rangers, compliance officers, people who are out on the road and maybe interacting with members of the public, maybe not in a way that the public perceives very well, and others involving travel or security officers and things like that. Going to the second general category. So like I said before, these are more likely to be perpetrated against the worker by their employer, co-workers, customers in the course of their employment. And they're defined in sections 8A, 8E, 8I, and B. So bullying now has a definition. That means an individual or a group of individuals repeatedly behaving unreasonably towards the worker or a group of workers to which the worker is a member. Racial harassment means an act that is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate the worker, and is done because of the race, colour, national or ethnic origin of the worker. Sexual harassment means a person who makes an unwelcome sexual advance, an unwelcome request for sexual favours to the worker, or engages in other unwelcome conduct of a sexual nature in relation to the worker. Then for the last one, so excessive work demands, that means work demands that are A, beyond the requirements expected of their role, B, repeated or persistent, and C, not reasonable in all the circumstances. Now, under Section 8M, there is a list of matters that can be considered when determining whether work demands made of the worker were excessive. And that extends to a wide variety of things, such as usual patterns of work, supervision of the worker, and the level of control over their tasks, surveillance of the worker, the nature of their role, their level of responsibility, whether they're entitled to receive overtime, the needs of the workplace, staffing levels, a whole range of things. Now, looking at these 4 relevant events, at this stage, we anticipate excessive work demands and bullying will be essentially the 2 main alleged relevant events around which most workers will present their claim. This is somewhat analogous to the current allegations we receive in psychological injury cases for bullying and harassment, overwork, and having a heavy workload. The definition of bullying is fairly broad, and we think it may be able to be established in some cases where no objective bullying took place, and the interpretation of behaving unreasonably is likely to be an emerging area of contention in commission proceedings. Now, for the relevant events in that second category, so bullying, excessive work demands, racial harassment, and sexual harassment, Section 8L now requires an objective test to be applied to determine whether the act or omission constitutes those 4 categories, so bullying, excessive work demands, racial, and sexual harassment. The worker's perception of the event, which previously allowed them to establish injury on the basis of their subjective perception of events, provided those events were real events, is now only relevant to the extent that their perception is reasonable. This is somewhat disjunctive because the reasonableness of a worker's perception and then also balancing that with the objectivity of that objective test that's required is likely to be another emerging area of contention because it's not quite clear how that will operate in practice. Now, like as we have now, all of these tests and criteria, which are obviously new, but they must be discharged by the worker so that the burden and onus of proof is on the worker to establish that they have a compensable primary psychological injury for the purposes of sections 4 and 8.0 before the statutory defence in section 11A potentially applies. So I'll now turn to a discussion of the expanded section 11A defence. So section 11A as we currently know it will be repealed and replaced with a new version if this version of the amendments goes through. As you may know, the old version required a work-related psychological injury to be wholly or predominantly caused by reasonable employer action taken or proposed to be taken with respect to 8 defined and limited categories. Now, the new section 11A replaces the previous one and says no compensation is payable under this Act in relation to a psychological injury, that being a primary or a secondary, if the psychological injury was predominantly, so that's a change from wholly or predominantly to just predominantly, caused by 3 things. A, reasonable management action taken or proposed to be taken by an employer in relation to a worker, or B, a worker's expectation of reasonable management action being taken in relation to the worker, or C, a worker's perception of reasonable management action taken or being taken in relation to a worker. So the responsibility and the burden of proof will still be on the employer and insurer to establish the defence because it is still a disentitling provision. The change is that rather than having to prove it was the whole or predominant cause, the insurer and employer will now need to prove on the balance of probabilities that the reasonable management action of, or the worker's expectation or perception of that, was the predominant cause. Predominant cause has generally been interpreted to mean mainly or principally caused, and it essentially maintains the status quo for that predominant cause test. Now, a big part of the 11A turns around what is reasonable management action. Rather than the previous categories we had, we've got reasonable management action, and that expands the various actions to which the defence can now apply. This is to be read in conjunction with 11A, so the new definition of reasonable management action, which is in section 8F. And this starts off by saying reasonable management action means management action taken in a reasonable way, and that is reasonable in all the circumstances. Then in subsection 2, section 8F goes on to provide a non-exhaustive list of what could constitute reasonable management action, and that can include things like appraisal or feedback, counselling, demotion, disciplinary action, dismissal, investigation by the employer into alleged misconduct, whether or not that's about the worker, or it could also be in which the worker was involved or maybe a witness, promotion, leave, provision of benefits, reclassification of employment, training in relation to their employment, that's the new one, transfer and communication with any of the actions mentioned in this section. Now, while many of those were in the prior version of 11A, there are some notable and important expansions to those categories to which 11A will now apply. Like I mentioned before, training will be one of those, and also communication in connection with any of the actions set out in the new defence. And also something that comes up quite a lot in the current version, which we can't often bring into the category of performance appraisal, we now have informal appraisal or feedback about the worker's performance and counselling of that, which previously fell outside of the narrow interpretation of the categories that we used to have. So in satisfying that the injury was caused by conduct that is in this non-exhaustive list, the employer and insurer will then need to prove that the management action was taken in a reasonable way and was reasonable in all the circumstances. This will be an interesting area of development and application, I think, if this version of it goes through, because the second component, so reasonable in all the circumstances, will give a lot of discretion to the Commission decision maker, as well as the use of and between taken in a reasonable way and reasonable in all the circumstances. We think that will make it quite difficult for the employer to satisfy both of those things. Because, for example, the Commission could find that the action was taken in a reasonable way, but it wasn't reasonable in all the circumstances, or vice versa. So the two expressions are probably going to be interpreted in different ways, and will likely be a main focus of plaintiff lawyers in circumventing the operation of the defence by proving that, well, it either was not taken in a reasonable way or it wasn't reasonable in all of the circumstances. The last comment I want to make just before I pass back to Mick about the Section 11A defence and the new version of that is that in practice, it's not yet clear how it will even come into play, because to establish psychological injury in the first place, as we've talked about before, the new definition requires the worker to establish injury was caused by a relevant event with an objective test. Now, reasonable management action is not one of those relevant events. So if, for example, bullying, sexual harassment, or excessive work demands are satisfied, and again, satisfied objectively, how can it ever be said that the injury was then caused by reasonable employer action or management action? When simply put, the basis of the claim is on the objective existence of matters that would fall well outside of the non-exhaustive list, even if it is expanded, and also how can it be said to be reasonable? So that would be an interesting area of development. Remains to be seen how it will be used in practice. And yeah, that's me done. But for now, I'll pass over to Mick, and he can take you through some of the more claims processes that are anticipated in this one.
Have we got any questions in the chat? Nothing at this stage? Okay. All right. So I'll say a few things about how psychological injuries will need to be dealt with in practice. I think there's a lot of uncertainty around the practice because it'll be governed to a large extent by regulations which we haven't seen, and also CIRA guidelines that might govern the practice of the management of workers' comp claims for psychological injury. For primary psychological injury caused by violent events, trauma, or criminality, the existing law in relation to provisional liability and claim liability will continue to apply. So there'll be no changes. So if we're dealing with psychological injury based on violence, criminality, or trauma, the process that currently exists in dealing with those claims at a provisional stage and right through the claim liability stage remains the same. What this bill does is to introduce a new methodology for dealing with primary psych claims caused by bullying, excessive work demands, and racial and sexual harassment. So that's what I'm going to focus on in my part of the talk. Psych claims in these categories: bullying, excessive work demands, racial and sexual harassment. I'll probably be a bit repetitive using those words because I want to sort of drum it into all of us that that's what we're dealing with, and this is where the significant change is occurring. If we have a claim in this category, an insurer will be obliged to deal with the liability decision within 42 days after the claim for a relevant injury is made. The insurer must either accept liability and commence weekly payments or deny liability within 42 days. If the insurer misses the 42-day timeframe, it is taken to have accepted liability. So it's a deemed acceptance. So from the perspective of the insurer and the employer, there will be a lot of activity within this initial 42-day period to understand what the worker is alleging, to get evidence in response to what the worker is alleging, including HR records and witness statements, factual investigations and matters of that nature. It's got to happen really quickly, because if we get to that 42 days, the liability decision will be made for us. My thoughts on the 42-day period. I think what an insurer will need to do is to triage from the outset all new notified psychological injury claims which are alleged to have been caused by relevant conduct, because different time periods, deadlines, and entitlements will apply if the psychological injury does not fall within this category of bullying, excessive work demands, and harassment. It may not be obvious from what is contained in the initial medical certificate of capacity or the incident report, or what the case manager is told during the initial contact with the worker. Sometimes workers change their narrative over time as to what has caused the psychological injury, either based on advice they receive or otherwise. So what we need here is processes to periodically vet and check how the psychological injury claim is categorised and whether it is or has become a relevant injury. That is, bullying, excessive work demands, sexual or racial harassment. My understanding is that it won't be enough for the worker to start the process by merely submitting a workers' compensation certificate of capacity, which is what happens now. My understanding is that there will be a requirement for a claim form. And I believe the regulator, CIRA, the State Insurance Regulatory Authority, is also toying with the idea of mandating the requirement of a witness statement by the worker to get the process running. So that's a significant change. And when you think about that, um, we don't often get statements so early in the piece from the worker. So that's a big change. But 42 days, it's not a long time to come to terms with what the worker alleges and then to investigate and obtain witness statements in response. So we need to be proactive. Disputing liability. The new section 280, capital A, capital E, sets out the requirements for disputing liability. The insurer must issue a dispute notice under section 78, which also complies with any regulation and guidelines that may be issued. The notice must be given to the worker no later than 42 days after the claim is made. The worker can seek a review of any aspect of the dispute. The review request must be determined and an outcome notified within 14 days. Now that's a pretty short time frame to deal with a review. It's currently what exists at the moment, but they've put a bit of teeth into it in this bill because failure to do so is now an offence, carrying a maximum penalty of $5,500. If a review decision is made, it replaces the previous liability decision. It's also mandatory for the worker to request a review of any liability dispute ahead of commencing legal proceedings. So you can't commence legal proceedings without the worker going through this review application process. I understand there will be guidelines that will deal with notification of liability decisions, reasons, and the procedure for conducting reviews. We don't know anything about that, but that's my understanding. It will come. If there is a liability dispute in relation to a relevant injury, i.e. bullying, excessive work, racial or sexual harassment, it can't be litigated before there is a review process. So where do we go with determining these disputes? Traditionally, we've gone to the Personal Injury Commission. But let me tell you, for this category of claims, bullying, excessive work, racial and sexual harassment, the liability dispute is not determined by the Personal Injury Commission. It will be determined by the Industrial Relations Commission. And there's a new section, or two sections, 280AH and 280AI. And that's not artificial intelligence, by the way. For psychological injury claims involving these categories, the IRC gets to determine the dispute, but only if the insurer maintains the dispute on the claim after review. The worker can lodge an application with the IRC seeking a decision about whether the conduct of the claim was relevant conduct. That is, whether there was bullying, excessive work, sexual or racial harassment. In dealing with the dispute proceedings in the IRC may try to resolve the dispute by conciliation, and if it's not resolved, it will be required to determine whether the conduct was or was not relevant conduct and issue a certificate of determination about the matters determined. Importantly, in making the determination, the IRC can have regard and consider any evidence from the employer asserting the conduct was reasonable management action taken or proposed to be taken. So if you've got a worker alleging injury based on a narrative of bullying or excessive work, usually that's what the old Personal Injury Commission or the Personal Injury Commission focused on. it didn't focus on the statutory defence. But here, the legislation says that if the IRC is asked to make a ruling on whether or not there was bullying or excessive work, the employer can put forward its contrary narrative of reasonable management action, and the IRC will have to take that into account in making its determination. This is not something that the Personal Injury Commission was accustomed to doing. Yes, there were two narratives in many of the cases, but if the worker got up on bullying, the 11A defence didn't apply at all. Here, the IRC has to consider it. Once the matter is determined by the IRC, it must issue a certificate of determination setting out the details of the determination and its reasons. This will be in a form approved by the President of the IRC, and it's yet to be determined. Importantly, the IRC determination about whether the alleged conduct was or was not bullying, excessive work, racial or sexual harassment is binding, and that issue can't be ventilated any further in the Personal Injury Commission. It's also important to point out that under the Industrial Relations Act 1996, there is provision for appeals. I won't go into that today because that'll take a long time. Even more importantly, if the IRC determines the alleged conduct was not relevant conduct, that is, if the IRC finds there was no bullying, there was no excessive work, there was no racial or sexual harassment, that's the end of the claim because the relevant injury is not established. So it's almost like having a committal proceeding before a trial. It's a bit like that if you can think of it in those terms. But if the IRC determines the conduct was relevant conduct, i.e. bullying, excessive work, harassment, two things immediately follow from that. The worker must give a copy of the certificate of determination to the insurer, and the insurer must not later than 7 days after receiving the certificate issue a decision notice about the claim. Presumably this means the insurer deciding whether or not liability is accepted and when the payment of compensation will commence. But there could still be issues in relation to incapacity and wage loss and need for medical treatment, and this may provoke the insurer to issue a further dispute notice. And when it comes to the further dispute, the subsequent proceedings are dealt with by the Personal Injury Commission. This is contemplated by Section 280 A I, which says if the insurer continues to dispute liability, the dispute must be referred for determination by the Personal Injury Commission. So that's the dispute process. Now, I'll make some comments at the end about what the IRC focus is likely to be compared to the Personal Injury Commission. But let's talk about the payment of compensation while this dispute process is underway. What happens there? Well, we know that the provisional liability regime, which currently exists, which is up to 12 weeks of weekly payments and up to $10,000 of medical expenses, we know that that doesn't apply. So when dealing with these bullying, etc. claims, what is the obligation to pay weekly comp and medical expenses? There is an obligation. Provisional liability doesn't apply, but the legislation, Section 280 A D, creates what I would describe as a pseudo provisional liability obligation titled interim entitlement payment. So this is how it works. If the worker is totally unfit, i.e. no current work capacity, the payment of weekly comp is pitched at 75% of pre-injury average weekly earnings, PRWE. If the worker is partially incapacitated and has some capacity to work, the payment is 75% of PRWE less any earnings they are earning in employment in suitable duties, or their ability to earn in suitable duties, whichever is higher. Whatever the weekly compensation amount calculated, it can't exceed the Section 34 maximum rate, which from the 1st of October will be $2,604.80. Most council workers in blue-collar jobs won't get anywhere near that cap. The worker is also entitled to medical expenses resulting from the injury up to a prescribed amount, and if there's no prescribed amount, it is $7,500. The interim entitlement payment, weekly compensation and medical expenses, ceases if the insurer decides to dispute liability ahead of the IRC proceedings, and it ceases 14 days after that decision is made. So if the insurer, gives notice of the dispute at, say, day 30, then the weekly payments cease at day 44. So it can creep over that 42-day period. Ultimately, the entitlement ceases 56 days after the claim is made. So let's take, for instance, a decision is not made, and at day 42, liability is taken to have been accepted. That's day 42. Then the worker has another 14 days to get to day 56 before the interim entitlement payment ceases. If the insurer decides to accept the claim, the worker is then entitled to what is described in the legislation as a back payment, which is the difference between the worker's entitlement to weekly comp under Section 36 in the first 13 weeks and the payment that was made at 75%. Now that back pay, that has to be dealt with fairly quickly. The legislation requires that the back pay be made no later than 21 days after the acceptance decision is made and communicated. Once we're beyond this interim entitlement, and assuming liability is accepted or established, normal transition applies in terms of the benefits calculation. So the normal Section 37 methodology in calculating weekly payments applies. A couple of red flags. It's an offence for an insurer to fail to commence weekly payments within the prescribed timeframes with a maximum penalty of $5,500. It's also an offence for an insurer to refer a matter for dispute that it knows is not a genuine dispute for the purpose of delaying without good cause the commencement of weekly payments. In other words, soft dispute notices or delaying dispute notices leading to proceedings either in the IRC or the PIC could land the insurer in trouble. And again, there's a maximum penalty of $5,500. Just a few other observations and comments. When dealing with the relevant conduct psychological injury claims, i.e. bullying, excessive work demands, racial or sexual discrimination or harassment, it seems unlikely that 11A, in whatever form it is enacted, will ever apply. Because if the claim is accepted, well, 11A won't apply. If bullying or excessive workload or sexual or racial harassment is found, it can never be the case that the injury was predominantly caused by reasonable management action. If we're dealing with a claim in the other category, a psychological injury born out of exposure to trauma, violence, criminality, then it can never be the case that the injury was predominantly caused by reasonable management action by the employer. I said it at the beginning, but if the IRC determines the relevant conduct did not occur, that's the end of the claim. Now, I think the IRC is potentially going to take a stricter approach to assessing whether there is bullying or whether there is excessive workload than what the Personal Injury Commission did when it had control of all of these disputes, particularly with the more objective tests that Maddie took you through earlier on in our talk today. If, however, the IRC, determines that the conduct did occur, there's just no scope for the employer arguing that it acted reasonably. Equally, some workers' compensation pundits are saying that Section 11A may have no work to do. So what we've got, what Maddie took you through, was a much more expanded version of Section 11A in terms of its categories, but with the tough two-pronged test of reasonableness. What the commentators that I've listened to are saying is that it may not come up at all. So we'll just have to wait and see. There's one other thing that I wanted to alert you to, and that is under the Industrial Relations Act, the IRC is vested with the power to issue stop bullying orders and stop sexual harassment orders. And if proceedings of that nature are brought, the IRC can award damages of up to $100,000. So that's not part of the Workers' Compact. That's other legislation. If the worker goes down that path, he or she cannot recover both damages and workers' comp. So they can't double dip. If they go down the damages part with the IRC, they can't go down the workers' compensation path. What is the role of medical evidence when dealing with liability disputes relating to relevant conduct claims? My comments at this stage are that insurers and employers should encourage insurers to continue to obtain clinical records and reports from treating doctors. Even if the relevant conduct is established, i.e. the bullying, either by acceptance or by determination of the IRC, there may still be issues relating to incapacity and wage loss and need for medical treatment, and these disputes may still have to be determined by the Personal Injury Commission. So we'll need medical evidence on incapacity and medical treatment. While it's possible for insurers to obtain a psychiatric IME within the 42-day claim determination period or during the period when the IRC intervenes to deal with the dispute, it is unlikely in most cases that the insurer will be able to obtain an early psychiatric IME report because of the restrictions posed by the regulator in its guidelines and the delays in obtaining psychiatric IMEs in practice. I don't think a psychiatric IME is vital to the proceedings in the IRC because the IRC determination is focused on the alleged conduct. But the clinical material from treating doctors may be relevant in highlighting the worker's complaint or lack of complaint about the workplace matters being alleged, such as bullying. A question in my mind is how far will the IRC go in looking into whether the worker did indeed suffer an injury, that is, a psychiatric disorder. I don't think the IRC will delve into this in great detail. Its focus is going to be more on the industrial issue, being whether the relevant conduct is established rather than the injury, which is more a matter for the Personal Injury Commission. Who pays for the IRC in matters where it's asked to determine whether the relevant conduct occurred? The cost of this new jurisdiction in the IRC will be borne by the Workers' Compensation Operational Fund, which is fed by employer premiums. Who pays for the legal costs of the worker in going before the IRC? That will be ILARS, which is the legal funding scheme that already exists through IRO. Will the employer or the insurer be entitled to legal representation before the IRC? Not determined yet, but the answer is probably yes. How will legal costs be dealt with in that jurisdiction? I'm told that the government is looking at a review of the statutory fee scale that applies to workers' compensation to provide for legal fees in work to be carried out before the IRC. So those are our comments about what the new environment looks like when it comes to psychological injury workers' compensation claims. To recap, there are two broad categories. The psychological injury born out of exposure to trauma, violence and criminality on the one hand, and the claim born out of conduct issues which often have the two narratives: bullying, excessive work, harassment on the one hand, reasonable employer management action on the other hand. This latter category, we've got to get our skates on to identify it, investigate it, and decide whether the conduct occurred. And if there is a dispute, to put on a dispute notice sooner rather than later, because we've got 42 days. There is a pseudo provisional payments regime available for this category of claims. And when we have a dispute, it'll go before the Industrial Relations Commission for determination. I don't think they're going to be too caught up in the medical evidence. They're going to look at the conduct. They're going to make a decision about whether the conduct occurred or not. And if the decision is that the conduct didn't occur, that is the end of the claim. If the conduct occurs, then it might find its way to the Personal Injury Commission for medical issues related to incapacity and the like. That's what we're looking at. That's what the reforms contemplate. I stress the bill is not law yet, but it will come because the state of New South Wales, the employers in New South Wales and workers in New South Wales need for this to happen, to bring financial integrity back into the system and also to bring certainty for both workers and employers. Watch for the guidelines and the regulations. There will be some devil in that detail, I'm sure. Stay informed and be prepared to work with your people in culture areas, with your business units and with your insurers to usher in this new environment. That's all we've got to say today. Maddie, do you want to see if there are any questions in the chat?
Absolutely. We just have one at the moment from Rod, which is, isn't some sexual harassment a criminal offence? I think fairly fair to say that yes, certainly it is. I think when we're looking at the relevant events and putting that into either the events born out of trauma or the category for sexual harassment, it may require some, I guess, assessment of perhaps the conduct that's complained about, and whether or not that is criminal conduct. But I think that may be given some more guidance in the regulations, and could be a thought area.
I'll just add to that. If a crime has been committed, it doesn't prevent the payment of compensation. If the injury is based on the criminal acts of a co-worker, for instance, and you get to a claim for work injury damages, a common law claim for negligence, there may be an argument to the employer to say that the employer can't be liable in negligence for the criminal acts of another employee that contributed to the injury. So the fact that the act which occasioned the injury is a criminal act won't stop compensation, statutory compensation being paid, but it may be of some relevance in dealing with the common law claim which may happen down the track.
And if the offence is indictable, then it would fall under the relevant event of indictable criminal conduct, which would allow an entitlement to compensation to be established as well.
Yeah. Are there any other questions? Be good if we had a couple. Okay, well, if there are no, oh, here we go. Oh, Mel. Oh, that's just a thank you. Our pleasure, Mel. If there are no, here we go.
Coming in.
All right, so there's some important questions in this lot. Do you want to shout out the questions, Maddie?
Absolutely. So first is from Reese. Hi, Reese.
Reese is one of our colleagues, by the way, and it's not a Dorothy Dixer. It was not planned.
Will the 31% WPI wipe out most psychological claims?
Okay, there should have been another slide, actually, and I'll talk to you about the eligibility to compensation for psychological injury. What these reforms do is they put a limit on weekly compensation for psychological injury at 130 weeks, and they place a limit on medical expenses for a year beyond the cessation of weekly payments. So in the ordinary course with these psychological injuries, your weekly comp stops at 130 weeks max, and your medical expenses a year beyond that, unless you establish a permanent impairment of 31% or more. That's what these reforms are saying. Now, 31% is really hard to get in psychological injury claims. We commonly see people exceed 15%. Often they get to 19%. In the more dysfunctional cases of injury, they get to 22% and 24%. You rarely see a psychological injury permanent impairment beyond 24%. Happens, but rarely. So at 31%, it's going to wipe out a lot of ongoing claims. And this is the reason, in my view, why the reforms haven't been passed, because it's viewed that at 31%, this threshold will put people out on the street. My view is slightly different to that. In these conduct cases of psychological injury, I often wonder whether there's an injury in the first place and whether what we're dealing with is a retaliation by the worker to what the employer is trying to do in managing the workplace and managing the individuals. So that's an important piece. This 31% threshold, if it comes in, it means that all of these claims will stop at 130 weeks of weekly payments and medical expenses 1 year beyond that. And this is what the government and the opposition are locking horns on at the moment.
Okay.
Does that answer your question, Reese?
Should I jump to the next one? So we've got from Zali Rogers, can you clarify the role of unions in the PIC and if this changes?
Well, unions are still going to be around and they're still going to be advising the worker, and they'll probably still tell the worker when the going gets tough, go to your doctor and get a certificate of capacity and start the process. So I don't think any of that is going to change. But if the regulator brings in more obligation on the worker in outlining the claims, such as a claim form, such as a witness statement, there may be some union involvement in assisting the worker to prepare those items of evidence. I think in the IRC, the worker will still be represented by a solicitor, and in the case of local government, more likely by the union solicitors, Carol and O'Day. And the same applies to the PIC. Does that answer your question, Zali?
Just read out the next one. From John Starr, will you be doing a similar session in regards to the other changes to the Work Health and Safety Act 2011, IR Act 1996 and IR Regulations 2020 and how it ties together?
Yeah, we probably would love to do that. I mean, our session today focused on psychological injury because those are the biggest items in the reforms, but the reforms have other things. There's some things about work health and safety in there as well. And then there's this other piece of legislation, the IR Act, that's been amended. I think we will probably do something on those matters with our workplace law and culture division. We might sort of tag team with them on that, but we haven't got anything prepared right here, right now. But when you fill in the survey at the end, John, feel free to not hold back. Whatever topics on your mind, put it in there and we'll have a look at it. Anything else?
I think that's what we've got at the moment.
Okay, well, we're 3 minutes over the hour. If any issues or questions emerge in your mind, you've got our contact details there on that slide. Go to Maddie first, and then maybe it might get to me. Anyway, I hope that was a good entree into what is bound to come in some shape or form in the next little while, hopefully before the end of the year. We thank you for your attendance. We thank you for supporting Bardia Perry's seminars and this particular event. We wish you luck in managing employment situations and claims under the current regime, and we will be there to help you under the new regime if you need our help. Thanks a lot and have a great day, everyone. Bye now.
Thank you.